Morning, everyone, and welcome. Welcome to Thompson Coburn's annual Government Contracts Update, our year in review. It's very nice to see you here. We appreciate your coming downtown so early. Special thanks, too, to our friends at the National Contract Management Association for joining with us today as well. I'm Tim Nolker. I'm a partner in the Government Contracts Group here in Washington, and we'll introduce our panel. Their bios are on the third page of your binder. But we'll introduce them as they speak as well. Most are from our Washington, D.C. office. Welcome, and without further ado, we have our first presentation on notable decisions and how they may affect your business from Kim Nucci, who's a partner in our Washington, D.C. office, and Scott Lane, who's an associate in our St. Louis office and known to many of you as well.
Good morning. Scott and I are going to talk about just a handful of what we call notable decisions, not necessarily because, and we mean decisions of the Government Accountability Office, the Court of Federal Claims, and SBA's Office of Hearings and Appeals, which we call OHA. We're calling them notable decisions not necessarily because they address new or novel issues, but because they address circumstances that we see occur over and over again, and we think that contractors should be aware of them so they don't fall into the traps that some of these contractors fell into that we were talking about. The first decision I'm going to talk about is VMD Systems Integrators, and it's about debriefings. And particularly debriefings for offerors who are unfortunately told that they were excluded from the competitive range. Typically you think, okay, well, I'm going to wait until they make the award decision and ask for a post-award debriefing, then I get more information. I find out why I was rejected, I find out why they selected the contractor that they did. That is not a good idea. When you are told that you're excluded from the competitive range and they ask you if you want a debriefing or they tell you you have the right to a debriefing, you should always request a pre-award debriefing. Often the agency will tell you we don't have time to give you one, we aren't going to give you a pre-award, we'll give you a post-award. That's fine. But you should always ask for a pre-award, because otherwise if you wait and learn about the award and you ask for a post-award debriefing, and even if you get one, you probably are going to get rejected at GAO because your protest will be deemed untimely. And the reason for that is because GAO's timeliness rule, and they're very strictly enforced, states that post-award debriefs protests are timely if you file it within 10 days after your debrief, provided that it is a required debriefing. The Competition and Contracting Act provides that the contracting officer is required to provide a post-award debrief to an offeror excluded from the competitive range only if that offeror requested a pre-award debrief and the agency declined to give them a pre-award debrief. I know it gets a little confusing, but the message here is if you're excluded from the competitive range, always ask for a pre-award debrief. You may or may not get it, but ask for it. The second issue I'm going to talk about is submitting a proposal that's the award is going to be against your FSS or GSA schedule. And in this case, the all-world language case, and in the U.S. investigations case, these solicitations involve services, so the offerors were required to submit personnel in certain labor positions. And so when you're proposing against a FSS or GSA schedule, you have to propose one of the labor positions that's already on your schedule. And you need to match up those positions with the positions that are in the solicitation and what is required there. In both of these cases, and I'm just really going to talk about the all world, the awardee company called SOS International proposed the cheapest labor rate position for a contract for linguists that were going to be provided in Afghanistan. And they got the award because they had the lowest price. And All World challenged that award decision and discovered that the labor position in the FS schedule that SOSI had proposed didn't match the requirements in the solicitation. The solicitation required much more experience and actually required the linguist to be in Afghanistan. GSA's schedule labor position that they used said that that position only worked at GSA's home offices. And so GAO sustained the protest and said you've got to align your labor positions from the RFP to the labor positions in your FSS schedule contract. The third decision that I'm going to talk about before I turn it over to Scott is involving the SBA's Ostensible Subcontractor Rule. I don't know if any of you have had experience with working with small businesses and 8A businesses and submitting proposals as a team arrangement, a prime sub arrangement, but frequently a follow-on procurement will be set aside for small business. The company that was the incumbent contractor no longer meets the small business size standard. So what do? They find a small business to prime it, and they'll be the sub. Makes a lot of sense. But you've got to be very careful with that arrangement. The inclination, of course, is why don't we just bring on all the same personnel? Right? Because they're experienced, they've been doing the job, so why don't we propose them as our personnel once we get the award, meaning the small business prime. That's a very dangerous thing to do because the ostensible subcontractor might come into play, and this ostensible subcontractor basically provides that it's a subcontractor who's performing the primary and vital requirements of the contract or is a company upon which the prime is unusually reliant. And what SBA will look at is first, is the incumbent ineligible and proposed as a sub? Now that's a red flag right there, but that doesn't necessarily have to occur for the ostensible subcontractor rule to be applied. They also look at whether you're moving the personnel from the incumbent en masse, or almost all of them, and principally the management personnel, are they moving to the new small business prime? And the other thing SBA looks at is how much experience does that small business sub have in that work area. So if you're planning to team together, you should at least, if you're this large business looking for a small business prime, you should find a prime that at least has a little bit of experience in the area that's covered by the solicitation. We've actually seen situations where the prime has selected, the sub has selected a prime that has never done this type of work before. That's very dangerous to do as well. And now I'll turn it over to Scott.
I may pop back for a second and invite any questions for Kim.
Sorry.
As we go along this morning, if you have any questions during the presentation, please ask them or hold them if you like till the end of each individual presentation. Plus, at the end of the morning, we'll have a Q&A session as well. Thanks.
Well, I'd like to add just one point to what you said, Kim, and that is with this debriefing. Basically, when a client tells us that they've been knocked out of the competitive range, we tell them, ask for that debriefing right away and pray that you don't get it. Because then when if the agency is going to delay it and you get a post-award debriefing, you get more information. But you have to ask. That's the key to this.
And agencies are getting a lot smarter about this. You say, okay, I want a debriefing, but you don't say pre-award or post-award. And agencies will often now come back and say, which one do you want? Because they know about this. And you always should say pre-award.
Good morning. My name is Scott Lane. I'm an attorney here in the St. Louis office in the Government Contracts Group. And I've also got 3 cases that I want to talk to you about. The first one here involves what's known as the late proposal rule. And the big takeaway is that in the past, whenever a proposal was submitted as late, the rules were very strict as far as you were pretty much out of it. But what we've been seeing over the past couple of years are several decisions, both at the GAO and the court, that are finding ways to bend these rules, particularly in light of the way electronic submissions are done nowadays, and in large part because the FAR hasn't been updated to reflect the realities of electronic proposals. It still talks largely about hand-carried submissions. There's an electronic commerce exception that deals with, it was essentially written for batch processing systems, and it's certainly not contemplated that proposals would be submitted through emails and different websites and file server exchanges. And so the first case that I want to talk about is actually this Federal Acquisition Services Team case, which was at the Court of Federal Claims. And the court, in regard to electronic proposals, has actually taken a little bit more lenient stance than the GAO. I mean, specifically here, the RFP required proposals to be submitted by email. And the solicitation actually said that the maximum file size that the contracting officer's email address will accept is 20 megabytes. And so the protester, FAST, submitted his proposal 4.5 hours before the deadline through one email that they had calculated as 18 megabytes. They think they were great, right? They go on, they actually were working on a different classified submission. The guy submits the proposal, goes into an area where he's got no access to email, doesn't ever check back to make sure it was received. Unfortunately, whenever it went through the agency's server system, the outer server that scanned it for viruses and tried to forward it on to the contracting agency server added about 7 megabytes to the file through the transmission process. And so the point is, from the math that I said earlier, the 20 megabyte limit and the 18 megabyte email, it was 25 whenever it hit the contracting agency server and got kicked back. And now remember, the guy's sitting in a classified SCIF somewhere, doesn't have access to his email, he doesn't notice the late delivery notification, and so he doesn't see what's happened until several hours after the deadline's passed. So first they filed a protest at the GAO, and what they argued is under the FAR there's an exception called the government control exception, which essentially says if the proposal is under the government's control prior to the deadline, you should be okay. But again, the FAR hasn't been updated for the current electronic environment, so what that means is a little bit ambiguous. And I say that because the GAO interprets there's a separate electronic commerce exception in the FAR that requires you to have submitted it one full business day in advance of the deadline. And this goes back to the whole batch processing idea, and essentially it doesn't at all contemplate email submissions. The GAO essentially says since there's an electronic commerce exception, the government control exception doesn't apply to electronic submissions because it would essentially render them superfluous. And so he lost at the GAO, but then he went to the court, and the court has, in several opinions, taken the opposite position that, they've basically looked at these exceptions and said, okay, the electronic one is outdated, and the government control exception is the best we have, and so they essentially allowed it in and said that the contracting officer should have considered it. The next issue that I want to talk about, and this also is not really a new issue, but it's an issue that pops up time and time again, and we see a lot of sustained protests at the GAO that deal with this issue, and it's relying on an affiliate's past performance. And so in this case, it involved a task order competition, which means that several contractors already held blanket purchase agreements, or BPAs, and the competition was limited to the contractors that already held these BPA contracts. PricewaterhouseCoopers won the award, and 3 other offerors filed protests. To understand the past performance issue here, it's important for me to point out, though, that the awardee was actually PricewaterhouseCoopers Public Sector, which is a distinct legal entity from its widely known corporate parent, PricewaterhouseCoopers LLP US. The public sector entity is focused on government contracts. So turning to the public sector proposal, in support of its experience, it relied in large part on work that was performed by its parent company. But nothing in the proposal provided that the parent company would be involved in performance of the contract. In fact, the best they had was in their cover letter. They noted that PwC Public Sector is a subsidiary of our corporate parent, and our corporate parent will provide substantial support throughout. They just generically said our parent will provide substantial support. The agency's evaluation didn't notice anything about this, but of course the 3 protesters did. And the GAO's stance on affiliates' past performance is pretty well established at this point, and it's that an agency can attribute the past performance of an affiliate where the proposal demonstrates that that affiliate's performance will affect performance of the contract. So what they're looking at is whether that affiliated company's workforce, management, facilities, financial backing, something is discussed in the proposal as somehow bringing benefits to this contract. So in that case, the GAO said that the cover letter was insufficient. And during the course of the protest, PwC, of course, intervened and tried to clarify all of the great support that its parent would provide and what it intended. But the GAO said it had to be in the proposal itself. In addition, the GAO seemed even more troubled by the fact that the agency evaluators didn't notice this, given the history of this issue, and in particular with how apparent it was on the proposals that that the past performance was of the parent and not some other entity. In an interesting twist, actually last week a decision came out at the Court of Federal Claims. The agency resolicited bids, and PwC filed a protest, a pre-award protest at the court, essentially trying to enjoin the agency from going through with the resolicitation, going through with the corrective action that GAO had recommended. And the court was essentially asked in that case to basically review what the GAO said and find if the GAO's recommendation for corrective action was reasonable, which is a really high standard for a protester to try and overcome. And with respect to past performance, though, the court actually suggested that it would have went the opposite way as GAO, but there were 3 other protest issues that were sustained at the GAO, and so the court just basically said, you know, these other issues are certainly things that we would sustain the protest over, and so they deferred, and so the protest failed. So the lesson here is clear. If you're going to rely on past performance of an affiliate, you have to discuss in the proposal how that affiliate's past performance or its resources or its financial backing or something will affect your performance of that specific contract. And then the last case that I'm going to be discussing is the GSA case, which deals with essentially fraud and self-reporting. So kind of a fun issue to end on here, but whenever you submit a proposal, obviously it includes a variety of certifications. And those may be submitted specifically for your proposal as an attachment, or you may be able to refer to the ones that are online on sam.gov, depending on the solicitation that you have. And one of the certifications that's always there is the certification regarding responsibility matters. It applies to any contract over $25,000, the simplified acquisition threshold. So hopefully you've all seen that one. Among other things, it requires the offeror to certify that neither the offeror or any of its principals is debarred and that none of them have been convicted, indicted, or criminally charged with certain crimes. So in that case, it surrounded a proposal submitted by a company known as Lewis Berger Aircraft. And it certified that none of its principals had been convicted, indicted, or charged with fraud. It made this certification in spite of the fact that 4 months earlier, the former chairperson of its parent company pleaded guilty to a 20-year conspiracy to defraud the government. In addition, the parent company had entered a deferred prosecution agreement regarding the Foreign Corrupt Practice Act violations and payments to Vietnam officials. So those issues were brought to the contracting officer's attention not by the company that submitted its proposal, not as part of a disclosure along with its certification, but by a competitor that obviously knew about all these issues and notified the contracting officer during the procurement. Incredibly, the contracting officer concluded that since Lewis Berger Aircraft was not directly implicated in the scandals, its failure to disclose them was not a problem. In essence, the contracting officer found that the company's complicated corporate structure had sufficiently insulated the offering entity from the crimes. So the Navy awarded the contract to Lewis Berger Aircraft based on its low price, and GSA, who had reported these issues to the contracting officer, filed a protest at the court, essentially challenging the responsibility determination. And so what the court looked at is there's a standard out there that intentional misrepresentations in a proposal disqualify that offerer. And then the court obliterated the contracting officer's rationale for brushing aside these issues. I mean, essentially, the contracting officer had found that the chairperson's guilty plea did not count because he had retired by the time the proposal was submitted. And so, you know, the court thought that this was ridiculous because it would create a loophole in the whole certification process, where if someone were convicted or charged with a crime, all the company has to do is oust them and then submit their proposal, and they don't have any issues. In addition, the guy still owned 25% of the company even though he was in jail, and so technically under the definitions he was a principal. So the takeaway here is that we are seeing a strong interest in self-disclosure and real consequences. In fact, for contractors that have lost a bid to other companies that may have issues, those may become viable protest grounds. And for offerers with a troubled past, those issues may be best disclosed up front rather than waiting for a protest to bring them all to light. And for government personnel, of course, always document your evaluation thoroughly, even for responsibility determinations, because you never know when those can come up in a protest. Thank you.
Thanks, Scott. Questions for Scott? One point came up, if you're new to federal government contracting, Scott mentioned the FAR. The FAR is the, as we say, as Tim says, the Holy Bible of contracting with the federal government. It is a collection of regulations in one volume that was an attempt to put in one place the regulations for dealing with the federal government. The current version is 2,082 pages long. It looks like the white pages of most big city phone books. And we have a question here?
The certification requires you to disclose within the past 3 years, so 3 years prior to submitted your offer, whether there are any of these issues.
And to pick up on what Scott said, regardless whether a contracting officer is aware of the actual facts, your competitors, there are no secrets out there. Your competitors are watching you like a hawk. And they go to your website, they watch the newspapers, they're collecting information on you. And so if you think that somehow you're going to skate by on something like this and it's worth the risk, you better think again. This is 2016 and everything is out there.
I might add too to one of Scott's cases that we've represented companies before who have acquired other companies and somehow in their due diligence missed some criminal misconduct by officers of the prior company. And when they go to compete for a new federal government contract, these issues do come up in past performance. And in fact, we've had one company propose for suspension and debarment based on wrongdoing by prior owners of the company that they did not uncover during their due diligence. So there's a word to the wise there. Regulatory update. We have a kind of a summary of a few new rules and regulations that came out over the past year. Some of them have been bouncing around for a little while and did get put into effect this past year. But Jana Rust from our DC office, who actually hails from Ironton, Missouri, is going to join me with this presentation and go over some of the new regulations. The big news item that you've probably heard over the year involves human trafficking, and we'll spend a fair amount of our few minutes on that issue and the new rules there. The themes involve more responsibilities over supply chains, more ways for the federal government to contract with small businesses, which is kind of a theme of our day with Scott Denniston here as well. And minority and women-owned businesses as well. And you'll see throughout, other than the last item there, a new reporting requirement involving past performance, you'll see a lot of the theme of labor and employment conduct within companies being regulated a little bit more than it already has been regulated. So, without further ado, we'll introduce Jana, who will start talking about counterfeit parts.
Hello. And just for those of you all who don't know exactly where Ironton is, if you went to Elephant Rocks or Johnson Shut-ins, that's my hometown. So it's always good to come back, even though I don't get to go down there in this great weather. So as Tim mentioned, we're going to start off talking about some of the supply chain things that we've noticed. And for those of you who have contracts with the Department of Defense, this is probably not anything new to you. The government is starting to put more responsibilities on prime contractors to have more oversight of their supply chains and not just bury their head in the sand. That's something we've seen with the counterfeit parts, which became a counterfeit electronic parts rule, and then cybersecurity as well. And these kinds of things that the government is requiring are more flow-down requirements, oversight, limitations on who the subcontractor or supplier might be, as well as reporting requirements. And all of those are things that come up in the context of human trafficking as well. And as Tim mentioned, it really is something that has taken the forefront, I think, of the government contracts community over the last year. And even within the last week, we've seen a couple of things come down the pipeline that will be impacting the way this human trafficking rule is implemented. And so I'll actually turn it back over to Tim real quickly to go through the prohibited trafficking related activities that are involved in the human trafficking rule.
Thanks, Shana. Human trafficking has been outlawed for a long, long time, and there have been regulations that control human trafficking, but pretty much until last year, March of last year, they only addressed pretty much the first 3 points there. Engaging in severe forms of trafficking, procuring commercial sex acts, and using forced labor. But long-term efforts came to fruition, again, last March, to flesh out a lot more of the requirements to be imposed to ban or to fight human trafficking. So, as we look at these, the real theme here is what kind of guidance does this offer companies, and employers? Because some of these are actually pretty broad, and you'll see a theme here too that a lot of them require you to be familiar with local laws in the area where you are doing business. So, and you may also wonder who's doing this out there, but a lot of folks are doing this kind of thing, such as destroying, concealing, confiscating, or otherwise denying access by an employee to the employee's identity or immigration documents. Companies often say to foreign employees, we'll hold your passport for you. We'll hold your employment papers for you. They'll be here in the office. That's illegal. Here's one that really is kind of a threat to employers sometimes. Using misleading or fraudulent recruitment practices or using recruiters that do not comply with local laws. Again, this is relatively new. We know there's a lot of activity going on out there, but it's really going to be up to the courts to define and continue to refine what a fraudulent recruitment practice is. There's lots of labor law out there that may address this, but there hasn't been much in the case law yet. The others are fairly self-explanatory, but I want to spend a little time on charging employees recruitment fees, because here there is a new regulation that came out this April. Actually, it was proposed this April. It's not yet formalized, that addresses the issue of charging employees recruitment fees. They've attempted to define it as any fees that go toward all or part of the cost of advertising a job, interviewing candidates for a job, training, testing, or providing orientation to new employees, or moving them for the job. The rule would also clarify that contractors may not assess fees to go toward obtaining labor certifications, visas, or processing petitions, or to pay for a government-mandated fee for an employee to cross a border or to have a photo taken for passport or other identification. Other activities that they propose to be barred under this fee ban involve qualifying fees to access medical records, medical examinations, or processing fees for background and security checks. So this will be incorporated into the FAR as we go forward, but that's the proposal that came out, again, just this April. Another couple of the areas here to look for, again, that are a little bit vague, are the last couple points: providing or arranging housing that fails to meet the host country housing and safety standards. You can imagine how there's some vagaries there, and there's some requirement that employers be knowledgeable of host country local standards as well. And the final one is pretty much self-explanatory. If required by law or contract, failure to provide an employment contract or other agreement in writing. So lots of activity in this area that Jana is going to continue to discuss in practical applications as we go forward. Thank you.
And so one of the things we've been seeing with this rule is that some of the folks in the contracting industry may be looking at this as a kind of a human rights issue or a social issue, but really the way the federal government has been treating this since the implementation of the FAR rule is really, it's a supply chain issue. It is dealing with your supply chain, where your goods are coming from, as well as the people you're hiring are coming from, and how they're coming to work for you or your subcontractor eventually. So some of these definitions really are important, but if you'll notice, we note that the definitions of subcontract and supplier, subcontract and subcontractor are very broad. For instance, the FAR defines it as any contract, as any contract entered into by a subcontractor to furnish supplies or services for performance of a prime contract or subcontract. So it's a very broad definition of where these regulations have to flow down to. And using subcontractors, of course, is going to impose some additional risks on prime contractors. Those of the prime contractors that have contracts that involve procurement of supplies from overseas as well as services performed overseas have to implement a compliance plan. That is mandatory for them for contracts that are over $500,000 that are performed outside of the United States, or where the supplies are obtained from outside the United States and the supplies are not COTS items or commercially available off-the-shelf items. So for those folks, they've already been hopefully starting to figure out how to implement this plan, even if they don't have a good idea how to do that. And one of the ways that the federal government has, I mentioned, been addressing this very recently within the last week is on Monday, a couple of non-governmental organizations released what's called the responsiblesourcingtool.org. It's a website that was funded by the State Department, and it includes multiple tools that go to addressing how to locate the weak points in your supply chain with regards to human trafficking, and it also includes a model compliance plan that can be developed after going through the steps with the tools. The tool for the compliance plan is definitely not meant to stand on its own, but it's meant to be used after everybody has gone through and really looked at their supply chain. But as far as folks using the tool, it doesn't get to your specific contract, it doesn't get to your specific business, your specific industry. It is definitely something that has to be tailored to what you all are doing. And if it's not, there are the risks for prime contractors, because there is no safe harbor for prime contractors for what their subcontractors do. So it is possible that a prime contractor may be held accountable for their subcontractors' acts. Also, a subcontractor violation will be posted to the prime contractor's Federal Award Performance and Integrity Information System records. So that's something that's going to impact the prime contractor down the road when competing later. And also, the prime contractor has a responsibility to notify the government when they find out that a subcontractor has violated this rule. So then, as Tim mentioned, this is something that a lot of folks really think may not be happening anywhere that they know of. But as we saw from a couple of cases in 2015, it is even happening here in the United States in industries that folks may not really think of as being susceptible to human trafficking. One of these was a shipbuilding contract in Mississippi, it was Mississippi and Texas. And what happened was, after Hurricane Katrina came through, this shipbuilding company couldn't get the number of workers they needed to do some of the work down in the Gulf Coast area. And they brought in some Indian workers on visas, so legal program, but they housed them in what would be considered substandard housing. They misled them as far as whether the employees who came over, they misled them as far as whether or not they would be able to get U.S. citizenship upon completion of the work, and they also required them to pay recruitment fees. So all of these things should sound familiar to you as things that are prohibited activities. It wasn't something that was covered by the FAR then, and at that point, we don't know if they had government contracts, but that company had at least one government contract in the past. So this is the kind of thing that may come up in an industry like construction or shipbuilding. But there was also a case in Ohio where it was an egg farm in rural Ohio. Apparently, it's the largest consolidated egg farm, I believe, in the United States. And the company there had brought in young Guatemalan boys and illegally brought them into the United States, housed them in these horrible trailers where they may have had one bucket for a bathroom, which I think that should probably describe to you substandard housing. And they were raided by the FBI, and those eggs, though, I'm sure, as you can imagine, definitely went into the supply chain somewhere along the way. And if there is an army base near there or any military base near there, those eggs probably were in some food supplier's supply chain that went to the federal government. So those are the kinds of things that you can think about as far as, are these things happening in your supply chain or not? They may not be, but there are weak points and they are things to be considered. And so then oh, sorry, was there a question over there?
I will ask it after you're finished.
Well, the question is, why didn't we serve eggs this morning, John?
I'm sorry, I'll ask you.
Okay. But then stepping back again from what does this mean in the context of supply chains in general? So this human trafficking rule, as well as the counterfeit parts and the cybersecurity issue, are things that prime contractors are probably noticing. They're going to have to be reviewing their flow down clauses and making sure that everything is being properly flowed down. They're going to be looking at their suppliers much more closely than they had before, or they should be doing that at least. And they're going to be establishing new compliance plans. So those of you who work with prime contractors, you're going to be noticing that these are things that you're going to have to be doing over the next couple of months and as things go on years, because things like human trafficking, you're going to see things coming up more and more. And as the federal government, as the folks who introduced responsible sourcing tool on Monday pointed out, it's not something you're going to be able to do, jump in and correct right away in your supply chain. It's going to be a process where you're going to be prioritizing where the weak points are. And then as far as subcontractors and suppliers go, you all are going to definitely be seeing more flow downs coming into those contracts that you're getting from your primes. And you may even be seeing some flow down requirements for the first time. You may not have seen them previously, but as prime contractors go through, really look at their compliance plans and figure out where they need to be doing these flow downs, you may be seeing flow down requirements for the first time from contractors you may have been doing business with for a long time in the past. And then I'll go through these next couple of slides fairly quickly because these go more toward the just an overview of where the regulations are. But the women-owned small business and economically disadvantaged women-owned small businesses rule really is a good example of more opportunities being made available to small businesses. It's something that was mandated through the NDAA of 2015. And it really does just give the federal government a way to provide more contracting opportunities to businesses that may have owners that are underrepresented in federal contracting. But with that benefit comes a bit of a drawback as far as women-owned small businesses previously could self-certify. So all of a sudden now the government's going to be looking at a way to make sure that the certification really is valid, and they've solicited comments as far as how are we going to do this certification program. So for those women-owned small businesses in here, that's going to be something that you may see a benefit to, but also you're going to have to be paying probably to have a certification done in the future. And then up here, this rule on equal opportunity and affirmative action for veterans and persons with disabilities. It's one of the labor and employment mandates that have come down, but what it is it's a very good example of the fact that HR policies and procedures need to be continually reviewed. This is a rule where contractors are prohibited from discriminating against qualified protective veterans and those with disabilities in employment positions. And so although that's just kind of an overview of the rule, this rule requires contractors to revisit their outreach, their recruitment, accessibility of employment notices, and even statements made in advertising for positions. So, and this rule came down in 2015 as a final rule. It was made an interim rule in 2014. So if your company hasn't been updating their HR policies since 2013, this is an example of one of the things that may need to be addressed. We've also seen, for instance, the gender identification rule that came down in 2015 as well, that was made part of the equal employment opportunity requirements that some companies have not been addressing in their HR policies as well. And so that is something to keep in mind as you go back through and look at your policies and procedures of what kinds of things need to be updated. This is an example of why your HR policies and procedures should be updated. And now I'm going to turn it back over to Tim to talk about the past performance reporting.
Thank you. Thanks, Jana. You've heard some references from Scott and Jana to dealing with parents, subsidiaries, and affiliates in government contracting going forward. And this rule is kind of separate from what we've been talking about in this section, but this imposes new requirements on reporting past performance when you're competing for a new contract, requiring subcontractors and grantees, contractors and grantees to disclose parent, subsidiary, and successor entities before the contracts or grants are awarded. It was published in March of this year, became effective in April, and it's something to watch for. The reason this is important is because it does factor into past performance evaluations as you compete for future contracts. And in drastic situations, it can even support suspension and debarment activity, again, if the conduct is egregious enough that is being reported, or worse, not reported. So this is something to look for as we go forward. And moving ahead, I'd like to introduce Tim Sullivan, who chairs our group. He's from our DC office, and most of you know Tim already, but thank you.
I'm not sure what that means, Tim. Thanks, Tim. Thanks, Tim. Good morning, everybody. As I listened to Jana and Tim, I began to think that perhaps the title of this little presentation should be changed from Compliance Hot Buttons, How Do I Avoid Getting Burned, to simply Piling On. Some of you know that President Obama has been pretty active in his 8 years in office in terms of using the power of the executive office through executive orders to change the way things are done in government contracting. And that's fair game. Presidents have done it before, and you may remember that Mr. Clinton was pretty active. And the first thing George Bush did when he came in office was basically delete everything Bill Clinton had done, and then that was flipped when Barack Obama came in, and God only knows what's going to happen in November, folks. I have to tell you, it's a scary thought, because if it were the standard Republican candidate we're talking about and he or she were successful, then I think we'd see that most of Mr. Obama's initiatives through executive order would be deleted. If it's Mr. Trump, I have no idea what's going to happen. I was telling my wife the other day, having watched the Tigers blow a 4-1 lead against the Nationals, that the only thing scarier than a Donald Trump presidency is watching a pitcher emerge from the Tigers bullpen. It's a scary thing to me. But this is a reminder, the fact that Mr. Obama has been so active doing this, these things, that government contracts has always been seen as a way to change and, in the eyes of the existing administrations, advance socioeconomic goals, try to achieve these goals. And in terms of the labor force and labor unions, this is exactly what's going on with what I'm going to be talking about now. In July of 2014, so roughly 2 years ago, Mr. Obama issued executive order, this executive order basically saying that we want to promote fair pay and safe workplaces. And within a year, the Office of Federal Procurement Policy and the major procurement agencies issued a proposed rule. And as we say here on the slide, it's going to change FAR Part 9. Tim and Scott have already mentioned the concept of responsibility. Before a contract can be awarded to anybody in the government marketplace, you have to be determined a responsible prospective contractor. And that is a very broad term. Takes into account a lot of different concepts, including integrity. And it's going to modify FAR Part 9. It's going to change FAR Part 22. We're going to get a new FAR Part 22, Fair Pay and Safe Workplaces. And the DOL has jumped in with FAR, the OFPP, to provide guidance on this. And when I talk about guidance, it's 100 single-space pages. And so all of a sudden, we've got the possibility here of a brand new rule coming in that's really going to require your focus, whether you're government or contractor. The rule was put out in proposed form in 2015. It went to the Office of Management and Budget. Comments came in, and on May 4th of this year, it went to the OMB. They take usually 90 days or so to decide whether the rule is going to go final. It can be extended, but there's a very good chance that even before the election in November, this rule is going to go final. Of course, we don't know exactly what it's going to look like, but we have a good idea because of what they proposed, and it's going to have an impact on all of us. Now, the rule requires, it applies to contracts over $500,000. It applies to, actually, contracts and subcontracts. So the prime contractors out there are going to begin having to have language in their subcontracts flowing these requirements down if the subcontract is over $500,000. So it goes down the chain. And what it says is that it's going to require prospective and existing federal contractors to disclose whether there has been, and look at the terms here, an administrative merits determination, a civil judgment, or arbitral award and decision rendered against them in the past 3 years, again, it's the magic 3-year look back, for violating any of 14 specific federal labor laws and executive orders or equivalent state labor laws. So boy, this is very broad when you think about this. It's a reach back. Now, I even see some of my government friends in the audience looking at this and saying, holy cow, because this isn't their idea. This is going to be put on them to enforce, and they realize this is a major issue for them as well. The only exemption, there are those of you in the audience saying, well, maybe there's a commercial item exemption, maybe there's a small business exemption. No, it's COTS only, the commercial off-the-shelf supply contracts. That's the only exemption from this requirement. Now, oops, I went ahead of myself. Okay, what are the statutes that are involved here? And we're not going to turn this into a labor law discussion, but the Fair Labor Standards Act, OSHA, the Migrant Seasonal Agricultural Worker Protection Act, the National Labor Relations Act, so the unions get involved. If you have union problems, now you're on thin ice in terms of responsibility. The Davis-Bacon Act, which applies to construction contracts. The Service Contract Act, which applies to any federal contract over $2,500. The EEO, Executive Order. Section 503 of the Rehabilitation Act of 1973. The Vietnam-era Veterans Readjustment Assistance Act of 72 and the Vietnam-era Veterans Readjustment Assistance Act of 1974. The Family and Medical Leave Act, Title VII of the Civil Rights Act, the ADA, the Age Discrimination and Employment Act, and an executive order establishing a minimum wage from contractors from 2014. That's a lot of stuff with the equivalent state laws. And so now you've got to be certifying as to whether you in the past 3 years have run afoul of this in any kind of determination. Now the Labor Department, with this single-space 100-page guidance on this, has different definitions of these terms depending on the statute. This is tricky stuff. So what might be reportable under one statute might not be on another. Kind of scary. What's going to happen here is that every agency is going to appoint a senior official as the labor counsel on these things, as the person to consult on these issues, and he or she is going to give guidance to the contracting officers with respect to how to treat a contractor's disclosed violation. Maybe it's not such a big thing. Maybe the contractors provided information that shows they've taken care of the problem, it will never recur, it was a one-off, they've mitigated it, whatever it is. But it's going to be a matter of discretion for the agencies, and they're in charge of doing this. Obviously, a lot of training is going to be required there, because they don't have it now, the senior procurement people. This is all new to them as well. Every contractor is going to have to certify with respect to these reportable violations with every solicitation that they're competing on, annually as part of SAMs, and in existing contracts that have this contractual language in it, every 6 months. So that during the contract, let's say you were clean and you got the award, and now you have a big problem you've run into, and there's an arbitration award that's been rendered against you, and the agency's upset about it, maybe they're going to decide not to exercise your next option. But you must report it, and they're posting this information on FAPIS, the website, so it's going to be all out there for the public. Now, everyone says that transparency is a great thing, and we're about to find out if we all believe that. So what lies ahead then? Now, let's say that these rules take effect on January 1, which I think would be the latest we'd see it if it goes through. Well, it certainly increases suspension and debarment risks for the contractors out there. And this is exactly what the folks who've wanted this executive order have been looking for. They want people at risk for mistreating their employees. Secondly, we're going to see bid protests. Again, your competitors are going to know what's going on here. They're watching your stuff. My partners have heard me say this. About 3 Easters ago, my daughter had a bunch of her single reporter friends invited over to our house for Easter dinner, and I sat there as one of them told me that her boyfriend works for a contractor whose name you all know, and his only job is to spend the day monitoring all the filings in the courts in the U.S. and the GAO filed by where their competitors are involved. And he said the intelligence you can get just from those court filings is worth its weight in gold. So they are watching you. This is his job. Kind of shook me up there. Potential False Claims Act violations. If you miscertify, once again, your competitors are going to be watching here. And they're going to try and blow the whistle on you. Friction between primes and subs. Oh yeah. As the primes are saying, before you get this job, we need this certification from you, and you're going to flow it down to anybody under 500,000. So it's going to create more compliance issues between primes and subs, and possible defamation claims. People claiming these violations have taken place. Someone gets hurt and loses out on a contract. They go after those people. So it's going to be the wild, wild west. We're a little concerned with respect to this new regulatory requirement. So what do we do? What should contractors do? Well, certainly you should conduct a self-evaluation of your labor compliance profile. Now, for a small business, that's not a big deal. You yell outside your door, have we violated any labor laws lately? That's great. But if you're Boeing, it's a different problem. And when you have 100,000 employees, it's not a question of whether you're going to have these problems come up, it's when and how you've resolved them. So you've got to have someone on top of this. And once again, it's bringing our folks from HR into working with contracts administration in a very close way, as they do on Service Contract Act and Davis-Bacon Act issues. You have to work with your HR people on these things. You have to assign a person, I'd call this person the victim, pick the victim, to study the executive order, the proposed regulations, and the DOL guidance. You've got to implement now a company-wide review program so that you're ready when the program is implemented. I would steal the Boy Scout line, be prepared. And when reportable events are identified, you take prompt action to ensure the problem does not recur. This is a little bit like past performance. I mean, it's not a matter whether you're going to have problems in government contracting, it's what you've done as a result of them. Someone who says to you, I've been married 40 years and I've never had an argument with my spouse, you know that person's lying. So you want to implement a program going forward to identify any covered violations promptly, because you want to beat the whistleblowers to the first base, don't you? I mean, you got to do this because you're being watched. Be very careful about voluntarily agreeing to any consent judgments or orders in these kinds of claims. Up till now, that's been something you do for business reasons. But now, wait a second, now it's got consequences. And you got to think about that. And finally, you can't treat any of these kinds of claims lightly regardless of the monetary exposure. It's not the money, it's the nature of the claim and the fact that it's reportable. So with that good news, I'm going to sit down and leave it to Tim to introduce Jeff Newman, but thank you very much. We had a client once that said they're so big that any labor dispute under $75,000, they just settled automatically. We were not allowed to litigate it. But now, you're not going to do that because that probably be reportable. Age discrimination, sexual discrimination, sexual harassment, discrimination among employees, whatever it might be. It's going to be different for every one of these 14 statutes. That's why you go to DOL. Some would involve agency decisions, other would simply be an arbitrator, for example. It's possible that if a lawyer files a complaint on behalf of a fired employee and you reach a $20,000 settlement with that lawyer, that's a reportable event.
Jeff Newman is a partner in our DC office and handles lots of client counseling and regulatory issues, is going to talk about classified contracting. Thanks. Here's Jeff.
Thanks, Tim. It's always a pleasure following Tim, especially when he steals the remote for the slides. Do you want to send that back? Now I can't even practice. Good morning, everyone, and thanks for coming.
I did that for the audience's benefit.
I'm sure you did. We're talking about classified contracting, and it's a little unfair to do this to you this morning. I mean, this is such a broad topic. Where do you start? Where do you begin in 15 or 20 minutes that I'm going to speak to you today on? Let me just start by saying what a classified contract is. Oftentimes, the contract itself is not classified, the four corners of the document, but the classified contract is one that is generally requires access to, and I'll repeat that again, access to classified information to perform on a contract. It could be as simple as how much to turn a screw on a schematic, a quarter inch, an eighth of an inch, or it could be something as significant as an entire DoD platform or defense missile system. And when I say access to can occur at the contractor's facility who needs a clearance. It could occur at a government facility, or it could occur at a third party's facility, another contractor's facility, a subcontractor's facility, as an example. So it doesn't have to be at your facility in general. Let me tell you a little story. I was walking over to the office this morning, and I don't want to say I first remembered this, but when I started putting these slides together, I remember an experience I had a number of years ago with a company called me one Thursday morning. I remember it was Thursday because I was going away that weekend, and needless to say, I didn't go away that weekend because of the issues that had sort of come up on the call. And this client, this company became a client, and it was a medium-sized business, had just done its first acquisition of another government contract. It was very excited. Had sort of finalized purchase price, had finalized all the contract terms and conditions, and then lo and behold, one of its banks, I think it was either Wells Fargo, Citi, Chase, one of the big banks, had some questions about the financing, and the financing had to do with certain contracts, three of which were classified contracts. And this company didn't really give much thought to classified contracts during the due diligence phase. What it did think was that there's a government form that was probably out there that they could fill out, and those government contracts, because all the employees were coming over and all the work was coming over, that they could just fill out a simple government form, and lo and behold, the classified contracts would transfer, if you will. Well, that obviously is not the case, and was not the case. So a year and a half later of having to delay the deal, revise and refine contract terms of the purchase agreement, the contractor finally closed the deal to the bank's liking. But the lesson there is some advanced planning is certainly warranted. And when you deal with classified contracting, you just can't think that it's a simple process, that the process could be taken care of in a few days, a few weeks, even a few months today. I mean, we'll talk about the length of trying to get a security clearance either at the facility level or a personal clearance today, and the time frames are strikingly concerning to folks who are trying to get those clearances to perform on those contracts. When dealing with classified contracts, I think the fulcrum here is the facility clearance. It's a complex process, as you can see on the slide. It takes at least a year to get a facility clearance today from the date you submit all your paperwork. This is a little bit of a facility clearance roadmap put out by the Defense Security Service. I will say DSS, the Defense Security Service, who's in charge of much of the classified contracting environment in the federal government, has terrific materials on their website. So if there are further questions or concerns, that's a wonderful place to start. And this is from a roadmap, the orientation handbook for facility clearances, and it really takes you step by step through the process. But this is just a sampling of part of the process here. And at the bottom of the screen, it talks about the initial review is 20 to 45 days, but that's only the initial review. And we have some clients right now dealing with some facility clearance issues, and it's 14, 15 months to get a facility clearance right now, and that's on the faster end of the spectrum. One thing to consider is that the ISRs, and there's a reference to ISR here, the Industrial Security Representatives over at DSS, they're very helpful, and they will be you should get them involved early on in the process with your company so that they understand if there are any particular safeguarding issues that they need to examine and evaluate with you, or to put steps into place, and have that conversation start early. Because once again, if you wait to the very end, it's going to either affect your deal, it's going to affect your performance on a contract, or it's going to perhaps even be your inability to get a government contract. Talk a little bit about the DD 254. I mentioned at the outset in that little story that I told, this client thought about there was a government form out there that they could take a government form and fill it out, and that would take care of the classified contractor. Well, there's a lot of forms in getting your facility clearance and personnel clearances and the like. The DD 254 is a place I'd like to start. And what is it? And all that form is part of the contract. It conveys your security clearance guidance. It advises contractors on handling procedures for classified material received or generated. It specifies whether it's secret, confidential, top secret on the contract. And I will tell you what it is not. It's not a vehicle for requesting that DSS verify any special procedures of the contractor, or that the DSS has to establish special procedures prior to the release of classified information. That is done in this process here in the facility clearance roadmap. The DD 254 does not take care of that. DD 254 is just part of the process to get the conveyance of what classified information is being provided under the contract. In terms of timing and considerations, they really go hand in hand, and maybe I should have had timing above the considerations bullet point on the slide. But first and foremost, I'd like to say there's really two types of DD 254s. There's an original, which is an original DD 254 that's usually contained with the solicitation documents. So if there's classified information as part of the proposal process, the government specifies at that time in the DD 254 what classified information will be there. And at the time of contract award, a new DD 254 will be issued, or the same DD 254 will be issued again. That's in the solicitation if there hasn't been any changes. But that is sort of the definitive document on what classified information and classification guidance will be used during the actual performance of the contract. Please note that the organization issuing the DD 254 is the organization that is providing the classified information. So if the U.S. government is providing the information to the prime contractor, the U.S. government issues the DD 254 to the prime. If the prime is providing the information to a subcontractor, the prime issues the DD 254 to the sub. And certainly the form should be prepared by someone who has knowledge of the contracting activity at the company with respect to the classified information, someone who has subject matter expertise, and someone who has technical expertise. And oftentimes it's not one person who has all three of those skill sets. So it's important when we're dealing with the DD 254 and putting that together that the right people are talking to each other and coordinating, so the right guidance is included in that document. As I said, contractors can use subcontractors to perform classified work, provided that the DD 254 is issued. And the subcontractor, if they are getting information that's classified, they too have to have a facility clearance. So the process goes down the chain in terms of, who has to have the appropriate certifications or the authorizations to handle classified information. Oh, sorry. And some considerations I mentioned before. Consider this early on in the process. Don't wait to the end where if it's a merger and acquisition situation, at the end to deal with how we're going to handle the classified contracts and who's going to be performing them. If you're thinking of bidding on a contract, you have to take the necessary steps, which we'll talk about in a few moments, to get sponsored or have the ability to access that classified information. And once again, the DD 254 only means is the only means for providing classification guidance as specific as possible under the contract. It does not include what safeguarding steps have to be taken, what procedures have to be in place at the company to handle classified information. And then certainly to revisit, your DD-254 at various stages of the process. There needs to be pre-award, award. If there's a new phase for the development of the program at R&D, classified information may be needed for the first time at that stage, or maybe, enhanced classified information needs to be handled at that point in time. If it does, a new DD-254 is issued. So anytime, the rule of thumb is anytime classified information is required under a government contract, a DD-254 has to be issued. Personnel clearances. I mentioned before, you can't get a personnel clearance until there's a facility clearance for the organization that's sponsoring the clearance. PCL personnel clearances are really taking up to 2 years now, unless there's some extenuating circumstances. We have a client who is in the process of transferring clearances, and we anticipate that's going to take 8 months just to transfer the clearances from one organization to another. Now, they could probably get interim clearances to handle that, and that probably could be done within a few weeks, and once their fingerprints are taken and some of the other documentation is filled out. But you're looking at a 18-month to 2-year process to get a personnel clearance. And I mentioned before, interim clearances for those working on programs that already have facility clearance and these accompanying personnel clearances. You can get interim clearances to help bridge that gap. But once again, you do need to think about that, with enough time that those interim clearances can be processed. Talk a little bit about the contracting officer and the DSS and what their responsibilities are in the process. I think there's an overarching question here, and that it really is there a need for classified information? And in terms of determining the need for the classified information, the contracting officer looks at that and makes the appropriate determination. The contracting officer will also verify that a contractor has the necessary facility clearance to handle that work. For sponsorship, and sponsorship is, for those that are not aware of it, if a government agency wants to provide classified information to the prime, it sponsors the prime, and if the prime wants to provide classified information to a sub, it sponsors the sub. And the sponsorship will require the contracting officer to ask DSS to take the appropriate action to make sure that the proper procedures and safeguards are in place at that contractor activity, so that there's no threat of inadvertent or intentional disclosure of classified information. And so that's the CO's responsibility, to ask DSS and those industrial security reps to take a look at that issue. And since there's a limited number of resources today in the federal government, and especially with clearances and the timeline that it takes to get either a facility clearance or a personal clearance, the government wants to efficiently use its resources in this regard. So the CO will also make sure that the security requirements for both the procurement process and the contract performance are being carried out in the most efficient and expeditious manner possible. Also should mention DSS. I've talked about them briefly. As I said, I think they're one of the better organizations to have to deal with in the federal government. If you're getting a clearance, they're very responsive, they're very receptive. The industrial security reps will often work hand in hand with you at the contractor level to make sure that, if they can expedite something or if they can make things easier, they will. I will tell you, they are very rigorous in making sure that there's no leakage of classified information, but generally our experience has been, and other colleagues' experience has been, they're fair throughout the process. Prime contractor, subcontractor responsibility, real briefly, for those situations where the prime is sponsoring the sub's clearance, you really want to make sure that the prime is passing down the right terms and conditions of the contract, but also making sure that the sub has the appropriate facility clearance and then the accompanying personnel clearances to perform the work under the contract. I should back up a little bit and say that it really is the responsibility of the government contracting activity to provide the appropriate classification guidance to the prime contractor as well. So the government has an obligation, and the prime has an obligation to make sure that the prime is receiving the correct instructions on how to handle the classified work, and in turn that flows down to the sub. The other issue is oftentimes the work at the, under a government contract is being performed at the subcontractor's facility, not at the prime. But the sub still has to go through the steps and work with the prime to make sure that all the documentation and all of its clearances are properly obtained. And finally, I want to talk about the merger and acquisition considerations. I mentioned those at the outset real briefly, but it really is important. We're seeing more and more of this in the M&A context. You know, I have a transaction right now where there's a number of classified contracts. But, you know, we've done some recently where there's, you know, one or two. And one or two contracts could really hold up a deal if the contract is that important to the acquiring entity. And it really needs to be addressed early on. There are mechanisms to deal with that delay in getting a clearance either at the facility level or personnel clearances or getting interim clearances. There are certainly mechanisms to address those issues. But you can't address those issues unless you're aware of them. So it's important in your due diligence process that if in fact you're looking at contracting, I think one of the first questions to ask is, you know, do you have any classified contracts? If the answer is no, then it's not an issue. If the answer is yes or I'm not sure, it's certainly worth a follow-up to make sure you have a roadmap to go forward. So with that, if you have any questions, happy to answer them, and I'll turn it back over to Tim.
Jeff, thanks very much. Another chapter in this idea of dealing with classified contracts involves disputes and litigation. If you're involved in a dispute or worse yet, litigation, whether it's administrative or in one of the federal courts, it increases the time it takes and the expense it takes to litigate. It's something to think about as you go into this. So Tim Sullivan is going to introduce our special guest speaker this morning, Scott Denniston, and take it away, Tim.
Thank you, Tim. 38 years ago, when I could call myself a young lawyer, in those days, before computers, before email, we would actually have meetings face-to-face with government personnel. Can you imagine that? We did it all the time. And I remember in 1978, I had a big Freedom of Information Act problem with the Small Business Administration, so I wandered over to 1441 L Street. And I always loved that because Nick Kalkunis, who ran the FOIA office at SBA, had 3 beautiful young women working in his office, and I always loved going over to these meetings. And so we go over that day, and because of the substance of the request at stake, they bring in another young buck named Scott Denniston, and he and I promptly get into a fight. Not fist fight, but it was a hell of an argument, and we've been friends ever since. Our hair is grayer today, or whiter in some cases, but we have maintained a great relationship with Scott as he worked his way through the SBA, getting promoted one time after another, and then ultimately someone figured out that he could do other things, and he headed over to the Veterans Administration, where he retired 7 years ago, Scott?
Yeah, almost 8.
7 or 8 years ago as the head of he was the SABU over there, and in his bio shows he was a very innovative small business representative over there. And since then, he's been very active on behalf of veteran-owned small businesses. He now owns Scott Group of Virginia. He works very closely with us, and some of you in the audience have actually worked with Scott as well. We're delighted to call him a friend. And we are really happy that we've tried to get him out here the last couple of years, but his schedule's pretty busy, and we finally got him here this year with the promise of great weather and a great baseball game. And it all worked out really well. So without further ado, I want to introduce our good friend, Scott Denniston.
Good morning. Don't worry, no slides. I'm technically challenged, so we're not going to do that. Now, when Tim invited me to come out, I said, well, what role do you want me to play? And he said, well, I want you to be the cleanup hitter. And of course, I knew most of the panel, and I was thinking to myself, well, that's a pretty powerful group. I'm not sure I'm going to be up to the task. And then, as we were at the game last night, and I was telling Jeff my concern, he said, well, look at it this way. The Cardinals cleanup hitter set a very low bar for you. Got a question for you. How many of you are government contractors? How many are large businesses? How many are small businesses? How many are veteran-owned small businesses? All right, see, that shoots the topic right there. We're not going to talk about why it's good to be a veteran-owned small business. Now, I will say, though, I happened to notice the time, and I was watching Jeff's presentation thinking, hey, you're cutting into my time. And it reminds me of a story of a little boy who went to church one day with his grandfather. His parents never went to church, but he was visiting with his grandparents, and Granddad took him to church. And the boy was just fascinated being in the church and asked all sorts of questions. He wanted to know what was the significance of the cross and what did the stained glass windows mean. He wanted to know what the communion rail meant. And the grandfather was incredibly patient and answered all these little boys' questions. Well, it came time for the sermon, and the pastor got up and took his watch off and put it up on the pulpit, and the little boy said, "What does that mean?" And the grandfather said, "Unfortunately, not a damn thing." But having said that, we will try to get back on schedule here. But one of the fun things about being the cleanup hitter, if you will, is you get a chance to listen to the other topics. And what's fascinating about government contracting today, and we're going to go totally off, I'm not going to talk a thing about veteran small businesses since it doesn't really apply to the audience, but I want to give you an overview of what I see going on in federal contracting today. And as Tim mentioned, and we won't say that we've known Kim as long as Tim, but it's been close. But the world of federal contracting is changing, and I'm not so sure it's necessarily for the good. I think one of the things that's happened, particularly in the last 8 years, that has not been good for the government and has not been good for us as a taxpayer has been this whole world of LPTA and lowest price technically acceptable. And I think what's happening is the government's finally realizing that it's not getting what it needs to do the work. And you were talking about, Scott was talking about his case with the affiliation and the contractor integrity. And we see more and more of that in the federal world because of this world of LPTA. And it makes it very difficult for incumbents to continue to have the work that they've had. And when we pile on that with the fact that most contracting offices have been shrinking in resources, and the people who are the contracting officers, the contracting officer technical reps, the program managers in the government, the ones with that corporate experience have left the government. And what we're faced with is a workforce in the government that is very inexperienced for the level of difficulty of the work that they're doing. And I'm executive director of an organization called the National Veteran Small Business Coalition. We're the largest trade association for veteran-owned businesses in the country that works specifically in the federal marketplace. And what we're finding is more and more examples of things that I'm sure all of you have faced where, as an example, an agency will put out a solicitation and they will give you 30 days to respond. But then it takes them a year before they do anything with it. And that's incredibly frustrating. And one of the things that we want to propose to whichever the new administration is, Tim, and I'll talk about my thoughts on that in a minute, is however long you give us to put together the proposal is how long you have to evaluate and make award.
Good luck with that.
I know, but I mean, that's part of the problem that we've got. We have situations where agencies will put out solicitations, small businesses and large businesses will submit their proposals, and then the agency cancels the solicitation. That happens all the time. We're in a fight with the Army at Fort Knox right now that put out a solicitation as a service-disabled vet set-aside, and they've amended the solicitation 6 different times. And they've changed the contract type and the contract methodology. So what that's meant is that those service-disabled vet businesses that are interested have had to submit 6 different proposals. And we've had numerous conference calls with the colonel. And I swear it's got to be one of these young guys that just got the lieutenant colonel rank, and he's looking for the bird on his shoulder. And he's the most arrogant SOB going. And he says, well, you do realize it's the government's prerogative. I said, we don't question your prerogative, we question your judgment. And it's things like this that make
another friend stop.
Absolutely, right? And what it does is it makes the government look to be a bad customer. And it makes more and more businesses say, why do I want to do business with the federal government? And particularly in the small business world, what the government is finding is even though it's making those dollar goals and those percentage goals, the 23%, it's making them with a much smaller number of businesses. Because the number of businesses that want to do federal contracting, quite frankly, is shrinking. because people just get fed up and frustrated by what's going on. Tim talked about regulation. The Rand Corporation last year, and this was a presentation I went to by a gentleman by the name of Jack Gansler, who was former Undersecretary of Defense, who now is a professor at Maryland. But the Rand Corporation did a study that on over-regulations and compliance, and it said that 25 cents of every DoD procurement dollar doesn't go for a weapon system to support the troops. It goes to compliance of government regulations. 25%. Think about that. And to Tim's point, what this study also pointed out was that many of these have been under this current administration. Because when this current administration came in, their position was that the previous administration had contracted out the entire government. And we were going to bring it back in and control it. And this is why there has been so much of the whole bringing back into the government things that this administration thinks are governmentally inherent, and why all these regulations and controls are being put in place. And the challenge is that it makes it much more difficult for you businesses, particularly small businesses, to comply with all these. So again, people are saying, why in the world do I want to do federal contracting? And I usually ask that question, and one or two, I'll say, how many do federal contracting? How many want to do? And then how many wish they did or have and never did? And there's always 2 or 3 hands that go up, and I swear those are the only honest people in the audience. Let's see, what else do we want to talk about? Let's talk about security clearances that Jeff mentioned. If you're a small business, he talked about the timing issues. And one of the challenges for small businesses is how you get those clearances. Well, if you're in that kind of world, NSA, National Security Agency, and NGA, National Geospatial Intelligence Agency, both have programs now where they will sponsor you for a clearance prior to you having a contract, because they now realize that the time necessary to get that clearance is such that chances are you're not going to be eligible for award. So if you're in that, that's important. The other thing that I think is important, and this gets back to what Kim was talking about protests and debriefings. I tell businesses all the time, ask for a debriefing. And the reason for that is the hardest thing for small businesses is to get time with decision makers. And the world isn't fair. Our oldest son, when he graduated from college and gone through 2 or 3 of his I'm going to make $1 million in a month schemes, and decided he needed a real job, went to work for Northrop Grumman. And he happened to be in the healthcare IT sector in business development. And Jeff comes home his second night on the job with a building pass. Well, after 9/11, getting building passes in government facilities is almost an impossibility. And I said to Jeff, how did you get that? And he said, well, I was with Frank, who works at Northrop, former VA employee, who walked me in the building. We went downstairs. He knew Sam. Sam took my picture, gave me the ID. What's the problem, right? Now contrast that with a small business who has to fight like a dog to get a building pass. And remember that the people that work for the government, I think for the most part, are very, very good people. They're very dedicated to the missions of their agencies, or they wouldn't be there. But they're risk adverse. And if you're not a known quantity, you present a risk to those people. And the old adage in the government is, if you make an award to a small business and they screw up, well, hell, they screwed up because they were a small business. Why in the world did you award that to a small business? If I take that same award and I make it to Northrop Grumman and Northrop Grumman screws up, well, heck, if they couldn't do it, nobody could. Maybe we got to go back and redefine our requirements. But it's not a level playing field when you're in the government market. And one of the things that debriefings give you the opportunity to do is have face time with decision makers. And if you go in with what I call the Army attitude as opposed to the Navy attitude, you would be amazed at what you can learn through a debriefing. Because they will tell you what work they have coming down the pike. They will tell you what work they know of people in their organization that are going to have. But that's only if you have the Army attitude. And the Army attitude is mission comes first. And you're there because you want to help their mission, because these people are mission oriented. Now, That's the Army attitude. The Navy attitude is this. Foggy day off the coast of New England. USS Enterprise, cruising along. It sees in the distance flashing lights. You know, the Navy does semaphore, and I don't know that because I was Army, obviously, right? And it gets closer and closer, and USS Enterprise, with its lights, says, this is the USS Enterprise, turn right. Actually, they said turn starboard, right? The light comes back, you turn port. Enterprise comes back. This is the USS Enterprise, the most powerful fighting ship and the most powerful Navy in the world. You turn starboard. The light comes back. This is the lighthouse, your call. Okay? So don't go in with that arrogant attitude. Go in with the attitude that you're there to learn. Because again, you present a risk. And when you go in to talk to any program manager, any contracting officer in the government, the question that you have to be able to ask them, that they have in the back of their mind, even though they're not going to tell you this, is what's in it for me? What do you have that is going to make their life and their mission easier to accomplish? And if you can answer that question, and you start to develop the relationships that are necessary, you can be successful in federal contracting. Because again, people are very mission-oriented. They make decisions in the government. How many of you have problems sleeping at night? Anybody? My word of advice, I'm not a doctor, but get a copy of the FAR that Tim mentioned, put it on your nightstand, and those nights when you can't go to bed, just open it up and start to read it. Within 3 minutes, you'll be asleep. Best advice I can give you. But the important thing is to remember relationships and remember the fact that the people who work in the government have a job to do. And the last thing they want to do is they want to see their name on the front page of the Washington Post or any other newspaper for screwing up. Because they understand that they're never going to have the resources necessary to meet the missions that they've got. And they are very committed to those missions. And if you can help them with their mission, they will figure out a way to do business with you. Let's talk a little bit about what's going to happen after November. As Tim said, it's a crapshoot. But quite frankly, I think, let's talk about the Donald. If the Donald wins, I think we're going to find much more of a business focus coming to the government. Now, I will admit that I think there's going to be some chaos in the beginning because I don't think they've even thought about a transition plan. And I would argue the most important time for any administration is the time from the election to the time of inauguration. And you've got to get your ducks in a row, get your policies established, get your people in place so that come January 20th, you're ready to roll. But I think there will be more of a business focus to come. I think that a lot of these regulations will probably be abolished or eliminated. And if Hillary wins, say what you want about her, but I think she's a policy wonk. And in my days in the government, and I think Tim would bear this out, the only administration that really took on trying to make the government more efficient and effective was the Clinton administration with Al Gore's Reinventing Government. And it was the first time that the government really looked at its processes and its procedures and said, what can we do to be more effective and more efficient to give the American taxpayer better value for their dollar? So I'm kind of optimistic that if Hillary gets in, that that same kind of approach will be used to the government. And I think that as everybody that's part of the process now looks at the process, we all have problems with it. And you know, we've got a number of fairly significant organizations around the country, people like NDIA, National Defense Industries of America, AFCEA, Armed Forces Communications Electronics Association, Professional Services Council, Coalition of Government Contractors. And they are all working on position papers on how to make the government contracting process more effective and efficient. And what are the problems today? And what's interesting is if you go to their websites and you start to look at what their concerns are, there's a very strong theme in there. And I think if we can take that theme, which is the effectiveness and don't worry so much about price, but worry more about quality, I think it's going to be much better for government contractors going forward if you, again, keep in mind the whole concept of mission. So I will leave you with that. Think in terms of mission, think in terms of how to make the government more effective and efficient, and I think you'll be successful. Thank you.
Scott, thanks very much.
You're welcome.
We still have, I know we had a little schedule challenge, but not much. Anyway, we still have time for open forum for question and answer. And we have more coffee and refreshments back there as well. Yes?
How much protection does putting the lowdowns into the subcontracts really afford you from these charges of violations of the labor laws and things like that? Once you put the flow-down in and it says put the substance of the clause in, you're not fully protected, correct? You can't be willfully blind to any, but do you have any obligation to search any further, or can you just say, well, I didn't realize that my subcontractor was violating these rules when they in turn subcontracted to overseas affiliates of theirs? Do I have any obligation to search those, search for information about those overseas factories?
Yes, to some degree, especially when you have the compliance plan that is required for the $500,000 contracts overseas. You, as a prime contractor, would have to certify that you have some kind of a program in place to oversee your subcontractors, and that does not just mean certifying that you've been including that flow-down clause. You actually have to show, well, you may have to show your compliance program, and so that will mean, you know, looking at and perhaps providing your subcontractors a survey of what their procurement policies are and who their suppliers are. So that's going to be something you're going to have to do probably before, or you would want to do before you certify to the government that you have some kind of system in place, because you really are going to have to be looking at your subcontractors, where they're getting their goods from, where they're getting their services from, whether or not, for instance, they use labor recruiters, because that's going to be a big question you're going to want to ask somebody who's providing services to you. And so it's not just putting that clause in there as a protection for you, because, I mean, we mentioned some of the things that, you know, could be a problem for you as far as the having it show up in your past performance records, but it's also, you're still subject to some of the same or all of the same issues that you might be for any other major contract issues: suspension and debarment, false certification if you don't have that program in place and you certify to that. So those are some of the other issues.
Probably not. The question was whether indemnification clauses are going to provide the prime adequate protection. Probably not. Certainly not from False Claims Act on the criminal side.
Do you even suggest pursuing indemnification here, or does that raise a bigger issue for your subcontractor?
I mean, what the government is really, I mean, and I guess it's a different question than what, or this is a different response, but hopefully we'll get to what you're asking. I mean, the government is really wanting to make sure that you're following through on this, and that you have oversight, you as a prime contractor have oversight of your subcontractors. So if you're trying to push that off onto your subcontractor, it's not really getting at the heart of what they're looking to get at. So that's something to think about, at least when you're looking at whether or not there's an indemnification clause. But of course, you know, you may want some help trying to fight something if a contracting officer comes in, or the EEOC comes in and looks at something. You may need your subcontractor to help pay for any litigation that comes out of that.
And I would add, just to maybe point of clarification for further discussion amongst us here, but I think when you're in your subcontract agreements, you know, you should have an indemnification clause that covers SCA liability. I mean, if the monetary damage, you know, that can be quantified. I mean, suspension and debarment makes it a little bit harder. I mean, I guess you could say any action arising out of that type of violation, if you go out of business, well, maybe there's a way to quantify that. But I do think indemnification, you should have False Claims Act liability. And we just did a deal, you know, that closed about a year ago, where there was an outstanding GSA investigation, not outstanding as in good, but one that was currently going on this client that company that our client acquired. And there was a specific carve out, much to the chagrin of the seller, that, you know, that would not be subject to normal indemnification. This was sort of above and beyond, had no limitation, well, a very high limitation, but that would be covered under that indemnification clause.
I might add too, on the regulatory front, there's yet another proposal being circulated to increase the penalties under the False Claims Act once again.
Almost double.
Word to the wise. Yes, sir.
The cultural standards. For example, if we have a contractor in Bangladesh and the requirements of our government supersede what the cultural standards are?
So it's the host country standard. So
Yeah,
if
you have
the
both,
performance of the
really.
contract is in Bangladesh, the housing is going to be very different there than what, is expected in Marion, Ohio. And so to that answer, depending on, for instance, in some places, outhouses, in different villages or something like that, that might be something that may be more acceptable in that host country as well as that specific locale. But not in some place like the Gulf. And one of the things Tim was pointing out earlier as well was the trafficking related activities that are prohibited. And so the labor recruiters that are active in other countries, they need to make sure they're following the host country, or I'm sorry, the country where they're recruiting folks, as well as what's under the FAR clause, because that's encompassed in there too.
Yes, Tim, in this labor law situation, is there any advice yet on how to?
Yeah, Mark's question was, is there any advice out there on how you'd structure these labor-related settlements in light of this pending regulation? I haven't seen it because the regulations haven't been finalized, but you'll remember that I'm not a labor lawyer, but I'm pretty sure that whenever you would reach a settlement with an ex-employee, a disgruntled employee, you want a confidentiality agreement, right? And you don't want him or her blabbing about this because it's bad PR for you. And now it looks like you may have to disclose it to the feds, and they're going to put it on a website.
Even though it's not a consent judgment, or
It depends on the law that's in
state law?
Yes, it depends on the statute or the order that's involved, and that's why this is tricky. Now look, it's creating a new empire. Someone at DOL had to write 100 single-space pages of guidance. This is how many people to do that? This is an empire, and boy, they're not going to want to get rid of this. So regardless who wins, Scott, I hope that they'll dump this thing. And by the way, there is an amendment pending for the National Defense Authorization Act in connection with that to exempt DoD contracts from this requirement. Now, I don't know what's going to happen there. If we talked about every pending piece of legislation here, we'd never get anything done, but it is out there, and we're sort of watching that.
Yes, again.
This topic hasn't actually been brought up yet, but under the government contracts update, the VA Prime Vendor Program, the changes that are occurring with current VA contracts versus what we're looking at from the NAC to the SAC.
Scott, have you been watching that?
Yeah, we've been fairly active in that. A little bit of background, the NAC, the National Acquisition Center in Chicago, has been for the last 30 years the organization that has been responsible for buying all pharmaceuticals, all medical surgical supplies, all major medical equipment.
For the VA?
For VA. And they're all federal supply schedules, and they can all be used by other agencies. Well, 2 years ago, the VA set up an acquisition office called the SAC, the Strategic Acquisition Center in Fredericksburg, Virginia. And it was one of these organizations that was kind of set up looking for a mission. And the mission has been evolving to the point where now what they are doing is they're putting in place national contracts for product. And they're also putting in place contracts for delivery of those products, which are called the prime vendor contracts. And we're talking medical surgical items for the most part. And the problem is, right now, and believe it or not, 2 weeks ago I was at a meeting of the Coalition of Government Contracting, their spring conference, and they brought the people from the NAC and the SAC together, and management admitted this was the first time that they had met each other, and they've been in existence for 2 years. So that's issue number one, that there's no communication between these two groups. And the process that VA is using... I'm sorry?
Are they somewhat adversarial?
Yes, very much so, because the NAC sees the SAC as competition.
It's a threat.
And they're both organizations that only survive if they have contracts that people use because they get the industrial funding fee. So the decision's been made that VA will do standardization of product within the medical centers for med-surg products. And the decision has been made that the SAC will do national contracts, but only for people who have products on the federal supply schedules. The federal supply schedules are what is done at the NAC. And the problem at the NAC is that it will take a year to do a modification, even a modification that is a price reduction to the government. It takes the VA at the NAC a year to do what DoD at Defense Supply Center in Philadelphia will do in 72 hours. So that's the first problem, because there's vendors, large and small, who have products that they're trying to get onto the federal supply schedule because the SAC wants to use them as part of the national contract competition, but they can't do that because they're not on the federal supply schedules yet. And it's when the process was first discussed last fall, industry, large and small, told VA they were never going to be able to do it. And VA had established an artificial date of April because they said that the prime vendor contracts that were in existence expired in April, and their general counsel said they couldn't be extended. So April was the date. Well, they never developed what they called a catalog of these items that the prime contractor was going to be able to deliver to the VA. So now the date's been pushed back to September, and I wouldn't be surprised if it's pushed back even further because the SAC and the NAC can't get their act together. So this is going to be a continuing frustration, I think, for industry. I'm sorry, go ahead. The contract award date. Yeah. Because VA has awarded the prime vendor contracts, but the problem is the catalogs haven't been in place with the national items on it that these prime vendors are supposed to deliver. So that's what will be the September date, and it'll probably get pushed back even after that.
So you're talking about the notice?
Yeah.
Okay, I work for Pfizer's.
Okay. And congratulations on your awards too, by the way.
How will the ability one contracts be affected by these changes?
You know, that's a good question. Because of the fact that, are you familiar with the Kingdomware case? Okay. Kingdomware is a case where, you know, VA has specific legislation called Vets First, where VA is supposed to buy from veteran service disabled vets first. VA has taken the position that that doesn't apply to the federal supply schedules, that FAR Part 8 has precedent over Vets First. There were a number of protests of that position to GAO. In every case, GAO ruled in favor of the service disabled vet. In every case, VA thumbed their nose at the service disabled vet and also at GAO. GAO got to the point where they told the service disabled vet community, look, don't bring us any more protests because VA is not going to change their rule. So a company called Kingdomware took VA to court. Kingdomware won at the first round, lost on appeal, because quite frankly, I think we had a judge that was smoking a bad dose that day. So it's the first case that I know of that actually has made it to the Supreme Court. And the oral hearings were about 3 months ago. And it was the very first case that was heard by the court after Justice Scalia passed.
Without Scalia, right?
Yeah. And it was interesting because some of us were able to sit in for the oral arguments. And it pained the court to have this case because what happened between the time that the VA won on appeal and by the time it got to the Supreme Court, the VA changed their whole legal argument. So now the Supreme Court's in a position where they don't have a precedent from an appeals court to go on. So we're waiting to see what the answer is going to be. Now the Supreme Court session ends sometime in the middle of June, so we're expecting to have a decision by then. And I think that decision will impact the Ability One program at VA. Because what you have now is you have a lot of Ability One vendors that are trying to team up with SDVOSBs and vice versa. Because most of the Ability One organizations have national mandatory contracts. The other flip side of it, the VA doesn't want to address is that they can't drive standardization because they don't have any internal controls. Quite frankly, one of my best clients is an Ability One who has a standardized contract that I provide data to every month on compliance. And the compliance runs between 50 and 70%. But we're able to use that data then to bang on VA and raise the amount of compliance. So VA is a very, very tough market right now.
The fact that Scott got into that argument is mind-boggling. Jana went over at what time, and you couldn't align?
I think I got there at 6 in the morning, but it was a packed house. There were a number of GAO attorneys, a number of us government contracts nerds that really wanted to get in and hear one of the few Supreme Court government contracts cases that come down the pike, and we couldn't get in. So unfortunately, I had to get by reading the transcripts of the case. But as Scott pointed out, one of the difficulties with it is the Court of Federal Claims had one decision, The appeals court overturned it on completely different reasoning than what the Court of Federal Claims had heard. And the government, you could tell as they were arguing at the Supreme Court, didn't really even agree with the Federal Circuit's decision there. But they were trying to figure out how to say we should still win, but just ignore that lower court decision. And so the justices were struggling with an already difficult area of the law, but then complicated by the fact that the opinion below didn't really provide them the background that they were hoping. But there was a dissent in that case at the appeals court. So it was 2-1, and you could tell, as Scott said, the justices were really struggling with even just understanding what a federal supply schedule is, what the VA's schedule is, and then there was a question that was asked of what's best value procurement, and it was just...
And the answer was awful.
Yeah.
As I recall. Yeah. Yeah, I mean, there are periodicals that cover our business, Gene, and there's plenty of websites, but I mean, I could, off the top of my head, and I'm sure the panel will add some, I think dollar for dollar, the best thing out there is the B&A Federal Contracts Report.
Yep.
It covers the industry anecdotally. It summarizes recent decisions. It gives you white papers on things. There's a publication called PubK Law, which has its own website now. You can judge for yourself the various blogs that are out there, but there are blogs, but you always have to worry about the accuracy of what's out there. It's just people yelling.
I would add...
What's GovCon?
GovCon.
Wi-Fi.
What is it?
Wi-Fi GovCon, that one?
Yeah.
I would also add NCMA's monthly magazine in the back always has regulatory updates from the last month. I mean, it's, of course, on a publication schedule that's delayed, and so it's not going to be nearly as immediate as B&A, but I mean, especially if you're looking to see as regulations are coming out and what might be coming down the pike, that always lists, you know, some of the acts in Congress that are being considered, as well as the regulations that have been passed or in proposed form.
Scott, where do you go for updates?
Do you work with the federal supply schedules?
Yes, he does.
I'm a firm believer that the coalition of government
Right.
contractors are the best. I'm involved with their medical and also with their small business committee. And what I like about that organization, it's one where we have periodic meetings with the decision makers in the government. I mean, we've had, probably a dozen meetings with E.G. Primus, who heads the SAC, and told him that his prime vendor program won't work. And large business particularly was very vocal about telling him that this thing was going to be a total disaster. And it turned out to be. But it's what I like about the organization, it's one that if you're on the federal supply schedule world, it's a great way to interact with the decision makers at the government so they understand what the issues are.
Yeah, it's the Coalition for Government Procurement.
Yeah.
Larry Allen used to be over there. For those of you who deal with the federal supply schedule, he's probably the best known person, and Larry still has a great relationship with them.
Well, many thanks to all of you for joining us this morning. Thanks to Scott Denniston for joining us especially, and thanks to the panel. And please call any of us for any follow-up here, and we look forward to seeing you again soon. And there's more coffee and refreshments. Thank you.
Thank you. Anytime.